Another portion we have is married women. Okay, when we talk about married women, husband's liability for wife's tort. Can we make the husband liable for the tort committed by the wife? So tort is a form of civil law which is uncodified. It's not codified. It has developed with time with common law principles coming into existence. At common law, if the wife committed a tort, there could be an action against both husband and wife because the wife could not be sued alone. So this was like previous thing that used to exist, that wife could not be, like a case could not be filed against the wife alone. So husband was also brought along in the case. A husband was thus liable for the tort of his wife committed after marriage. Once she gets married, after that, husband was also dragged into the matter. There was one legislation that came in England under the Married Women's Property Act 1882. A husband was also liable, okay, for prenuptial torts of his wife to the extent of property he acquired through her. If she had committed something even before her marriage, for that a case is pending and the case was being decided, for that also we can make the husband liable. But he will not be liable to pay compensation from his own pocket, but he will be liable to pay compensation to the extent of property that he acquires through her. Because of the marriage, if he has acquired any property through her, to the extent of property, he will be held liable, not like he will pay from his own pocket for the tort committed by the wife. But there was a reform that came into existence, law reforms, Married Women and Tortfeasors Act 1935. It changed the position, and now husband is not liable for tort of his wife, whether it was committed before the marriage, after the marriage, does not matter. We cannot bring husband in the case just because he is her husband. If the husband and wife are joint tortfeasors, both of them jointly committed some tort, they can, however, be made liable jointly in such cases, which would apply in any other matter also. If two persons jointly commit something, we bring both of them in the case, right? So in that sense, if both of them have committed something, there we can make them liable. But just because of existence of this relation, husband and wife relation, we cannot bring the husband also in the matter. So as such, just because of existence of husband and wife relation, we cannot make the husband liable. Same thing even we get when we study CPC, right? If there is a women cases being filed against her or by her, thereafter she gets married, there will not be any changes as such in the case. The case would go on just like that only. So even though this is something which we have derived from common law, even in CPC we have provisions relating to that, that what are the, like rights and obligations of a married women, how is it going to affect their like situation, like that we do have provisions. So same thing is being followed. Wife would be considered as a separate individual. If she has done something wrong, she will be held liable for that. Same way, husband has done something wrong, husband will be held liable. If jointly they have done something, then only joint liability of both the husband and wife would come into picture. Okay, is this part clear?
Yes, ma'am.